Hi again, everyone. Thanks for coming back and joining us as we finish up our basic financial literacy lecture series for physicians. Today, we're going to talk about how we ensure that all of our hard work ends up in the right hands after we pass on to greener pastures. Yes, this lecture is all about estate planning. Don't turn it off. This is important for everyone. But before we get to that, this familiar slide is another quick reminder about our goal of true wealth. I'm not going to spend any more time with this definition. You should all know it by now. And here are the milestones on the journey. At this stage, it's all about giving back, because nothing feels wealthier than being able to give some of what we have to others. These final two milestones are all about that, controlling how we can share our good fortune with those around us that we care about. So let's get into it. Some people have the misconception that estate planning is only for the ultra rich, or if you're still young, something that you can put off until after you retire. Well, both of those sentiments can't be farther from the truth. Estate planning is for everyone. It's merely about being sure that you control where your assets go after you die. Doesn't matter how many assets you have, you still want to be sure that they end up in the correct hands, right? And that the government doesn't needlessly take a big chunk of them from your heirs. It's not just about assets, though. Do you have dependent children? If both you and your spouse die suddenly, who would you want to take care of them? Designating your preferences in a will is a critical part of estate planning as well. It's also not entirely about what happens after you die. Another important aspect of estate planning is about choosing who you would want to direct your financial and healthcare decisions if you're still alive, but no longer have the capacity to make decisions on your own for some reason. Finally, for those that are super wealthy, proper tax planning for your estate can help you pass more of your wealth on to the next generation rather than into the hands of the government. This slide lists the estate planning modalities that everyone should have or consider, regardless of your income or net worth. We'll go through each one. First, what is a power of attorney? It's a written agreement allowing one individual, called the agent, to act on behalf of another individual, called the principal. With a general power of attorney, as long as the principal can make their own decisions, they are allowed to do that. But if the principal becomes disabled or incapacitated, the power of attorney can step in. You don't have to be incapacitated to use a power of attorney. A limited power of attorney, for example, can be used if the principal just wants someone else to act on their behalf for certain things like securing a contract or investing in certain assets. In that case, the principal would give the agent authority to act on their behalf for that particular transaction. A durable power of attorney means that the power to act on behalf of the principal begins at the time it's created and lasts for the principal's lifetime, regardless of if the principal becomes disabled or incapacitated. This is in contrast to a springing power of attorney, which only takes effect after the principal is deemed disabled by a physician. So what's the problem with the springing power of attorney? That kind of sounds like what we want, right? Well, the main problem is that it takes some effort and time to establish that the principal is incapacitated and that the power of attorney can begin to act. That window may be when a lot of critical decisions need to be made, but the agent would still be powerless. So a durable power of attorney is generally the safest way to go. You obviously want to choose someone who you trust and who you know will make good decisions for you. Decisions in your best interest. A power of attorney is a legal document and best created by a lawyer familiar with all the nuances, although there are ways to do it for less money online. When you create a power of attorney, you want to be clear about the specific duties you are giving them. You can create different powers of attorneys for different things. For example, you can choose one person for your finances and another for your healthcare decisions. You might trust different people to make those specific kinds of decisions for you. If you just want someone to make healthcare related decisions for you, but nothing else, that's called a healthcare power of attorney. That is very important to do as soon as possible because you never know when you could become a victim of an accident or an illness where suddenly you are no longer in a position to choose for yourself. Having a healthcare power of attorney allows that person to make decisions on your behalf in consultation with the physicians that are caring for you. Be sure they know what you would want ahead of time if you were to find yourself in that situation, or it is someone that you trust to act in your best interest to make decisions that you would want, not necessarily what they would want. For example, would you wish for doctors to do everything they can to save your life and keep you alive even though your prognosis and quality of life is poor. If not, tell your power of attorney. A related document is a living will or an advance directive. This is a written statement that details your wishes for medical care if you can no longer give consent. How aggressively do you want your medical care to be if you have a poor prognosis? If you suffer a cardiac arrest, do you wish to be resuscitated? If you have a debilitating stroke or a brain injury, would you want to be put on a ventilator and fed through a feeding tube just to keep you alive? These are some of those examples. Since this YouTube series is directed at physicians, most of you know the medical implications of all of that and the value of knowing what the patient would have wanted for themselves before you go too far down a certain path. So be sure you take care of it for yourself. All right, moving on, let's talk about wills, otherwise known as the last will and testament. This is a document that allows the person who creates it, known as the testator, to control the passing of property interest to others after they die. Property transfers are regulated by state law, not federal law. So be sure you understand the process in the state in which you live and also the state where the property may be. If there is no will, the state determines who should inherit your assets, and they typically divide them between your spouse and children. If that's not what you would want for whatever reason, though, you better have a will in place. When you die, all of your assets that are not otherwise designated to go elsewhere, more on that in a minute, goes through a process called probate. This is a legal process with a judge and a court involved, and it's open to the public to learn all about what you have and where it's going. The first step in probate is to determine if there is a will and if it is properly executed. The next step is to determine if anyone has a claim against your property. In other words, do you owe any debts? Everyone that has a claim will have the opportunity to file that claim to try to get their share of your assets. Then the judge determines the final distribution of whatever is left over according to your will, as long as it's not contested by your family members or whoever feels like they were shorted. The more creditors' claims and contests against your will, the longer it will take to settle it, and the bigger chunk the probate court will take from your assets. As I mentioned earlier, the other extremely important part of a will, especially when you were young, is for you to designate someone who would take over guardianship of your minor or disabled children. Without that, the judge decides. In reality, the judge doesn't have to take your recommendation, but they almost always do because they will assume that you know best. So just keep that in mind if you keep putting off getting your estate documents done. You probably have strong opinions on who would be best to help take your place in raising your kids. Don't leave it up to the court. Although a will is important, it is actually cheaper and easier to use the various options of passing down your assets outside of the probate process. These are called will substitutes. So will substitutes allow your assets to pass directly to the people that you designate as beneficiaries and are excluded from the probate judge's decisions. Will substitutes are divided into three categories: trusts, operations of law, and contracts. A trust is a legal entity that holds property and allows the creator of the trust, called the grantor, to coordinate that investment, use, and distribution of property through a trustee. Trust can be established while the grantor is alive, called a living trust, or after death if directed in the will, a testamentary trust. They can be revocable, which means the grantor can modify the terms, or irrevocable, where the grantor cannot make changes after it's created. A revocable living trust becomes irrevocable upon the death of the grantor. The assets held in a trust do not go through probate, but are distributed by the trustee according to the terms in the trust. If it is an irrevocable trust before the grantor dies, it's removed from the grantor's estate entirely, saving on estate taxes. Operations of law relate to how the property is titled. The titling that avoids probate includes joint tenancy with right to survivorship and tenancy by entirety. In the case of the first, the ownership flows automatically to the other owners of the title. In the second, it goes to the spouse. Contracts include life insurance, annuities, and retirement accounts. These allow you to designate a primary and contingent beneficiary and are passed directly as designated on that contract at the death of the contract holder. Be sure that you have beneficiaries designated and update your beneficiaries regularly, especially if you get married, divorce, or add children to your family. Let's talk for just a minute about estate tax. This is a wealth transfer tax that the government charges at the time of your death on the value of your estate before it passes to your heirs. The reality is that most of us will not have to worry about this unless the current limits change. In 2024, you will only owe estate taxes if your personal estate is worth more than $13.61 million. If you're married, your combined estate would need to be worth twice that before you pay taxes on it. Up to that number, there are no taxes due. After that, the tax bill is hefty, quickly reaching 40%. There are a variety of strategies to shelter this money from government taxation, including transferring assets to irrevocable trusts, gifting them away from your estate, lower your estate by giving away some of it while you're still alive, and giving money to qualified charities after you die. There are also strategies to delay the tax by transferring assets to your spouse and ways to give them to your children or grandchildren. Okay, let's wrap this lecture up. Remember what the point of estate planning is. It's to be sure that the results of your hard work end up in the hands of the people or charities that you choose, not those that the judge thinks are most appropriate. It's also to prevent the probate court or government from taking a sizable chunk of what you have worked hard to accumulate. And it is also to protect your decisions and wishes if you are incapacitated, or who you would want to take care of your children if you meet an untimely early death. Most of us won't need to worry too much about estate taxes, but some of us will. And for those that do, effective planning can save a lot in taxes and allow you to leave more to your heirs. Although estate planning is not super exciting and it's tempting to put it off until later, I encourage all of you to make the effort to get this done. As an emergency medicine doctor and a financial planner, I'm all too familiar with situations where families procrastinated until it was too late. Thanks for listening. Please hit like and subscribe to the channel. Share this information with your friends and family. We'll see you next time for our final and related milestone about charitable giving. Take care.